Hi, I'm Malcolm Burrows, Principal of Dundas Lawyers. Dundas Lawyers is an award-winning corporate technology and intellectual property law firm that also passionately litigates in these areas of practice. On 23rd of February 2018, a new Notifiable data breach scheme came into effect across Australia, making it mandatory for eligible entities to notify the Office of the Australian Information Commissioner, OAIC, and the affected individuals about eligible data breaches. This video attempts to explain who the data breach scheme applies to, just what is an eligible data breach, and how you can assess if a breach is an eligible data breach. The scheme applies to APP entities which are not small businesses as defined in Section 6D of the Privacy Act. APP entities include entities that have an annual revenue of more than $3 million, or accrediting reporting bodies and credit providers. However, it also relates to what are termed non-exempt entities. These include, amongst others, entities that provide health services, ISPs, telcos, entities that trade in personal information, service providers to the Commonwealth under a contract, and entities who operate a residential tenancy database, and any entity who holds tax file numbers in specified circumstances where the breach involves tax file numbers. An eligible data breach occurs where there is unauthorised access to or disclosure of information, or such information is lost, and a reasonable person would conclude the access or disclosure would be likely to result in serious harm to the affected individuals. Classic examples include things like an employee laptop being lost or stolen, or an Excel spreadsheet simply is emailed to the wrong recipient. A database containing personal information is hacked or even stolen by an employee, or the classic hacked by Russians. If in assessing whether a reasonable person would conclude that the data breach is likely to cause serious harm, an entity should consider the kind of information, the sensitivity of the information, and whether the information is protected by security measures, and the likelihood of those security measures being overcome, the kind of person who could have obtained information, and the nature of the harm that may arise. In other words, each case needs to be assessed on its own merits. Then, the entity should consider the legal concept of the reasonable person. That is, would a reasonable person standing in the shoes of the responsible person for the entity conclude that in the circumstances the breach is likely to result in serious harm? While serious harm is not defined in the explanatory memorandum, the explanatory memorandum indicates it would include serious physical, psychological, emotional, economic and financial harm, serious harm to reputation, as well as other forms of serious harm. It would not include people who are distressed or upset, or access to that loss. For more information on this topic, please see our website. If you're looking for a technology law firm to advise in the development of a data breach response plan, or advise in the event of a data breach, please don't hesitate to calling on 3221 0013 for a confidential, obligation-free discussion. Thanks for watching.